This week at the Supreme Court, a simple question will sound difficult. Can a former president be criminally prosecuted if he tried to steal a presidential election through a campaign of lies and political bullying that apparently violated multiple federal criminal laws? That is the question the justices have chosen to confront on Thursday, when they hear oral argument in Trump's pre-trial appeal from the Justice Department's prosecution in Washington. The outcome will undeniably shape the 2024 election. Some commentators have insisted that the issues aren't simple, that they are sprawling and complicated, and that the court must grapple with the implications of its ruling in this case for future presidents to come. Legal framing is often a deliberate choice. The court can and should have resolved this issue narrowly and quickly. But instead, the justices chose to hear arguments, a decision that already has imperiled, possibly fatally, the prospect of a trial for Trump on January 6 charges before Election Day. Even if Trump ultimately loses at the High Court, that delay may already have provided him with a de facto form of immunity, since he could easily escape judgment before the election. And if he wins re-election, it will have been as good as a get-out-of-jail-free card. Unfortunately, there is still more that the conservative justices can do to help Trump out. The correct answer to the question in the United States of America, where colonists waged a war to free themselves from the rule of a king, is clearly no. Indeed, Trump's argument for immunity is, at least in its strongest form, crazy, as Michael Dorf, a constitutional law professor who currently teaches at Cornell Law School, told me last week. Dorf clerked for Justice Anthony Kennedy, hosts a lively and insightful blog that features some of the most clear-eyed commentary about the workings of the court today, and also holds the dubious distinction of having been my constitutional law professor years ago. Intuitively, most Americans appear to recognize that Trump's arguments are absurd. In a recent Politico/Ipsos poll, 70% of respondents, including nearly half of Republican respondents, said that they do not believe that U.S. presidents should be immune from criminal prosecution for alleged crimes that occurred while in office. Trump first asserted his crazy argument last October, and U.S. District Judge Tanya Chutkan rejected it in December, in a rigorous and well-reasoned opinion. Trump appealed to the D.C. Circuit Court of Appeals shortly thereafter, resulting in a stay of the pre-trial proceedings and an indefinite adjournment of the March 4 trial date that Chutkan had previously set. Justice Department Special Counsel Jack Smith asked the Supreme Court to hear the appeal straight away, but they declined that very sensible proposal. In early February, a three-judge panel of appellate judges affirmed Chutkan's ruling in an even more thorough and compelling opinion, ultimately holding that any executive immunity that may have protected Trump while he served as president no longer protects him against this prosecution, which concerns, among other things, the citizenry's interest in democratically selecting its president. Days later, Trump appealed to the Supreme Court, and about 2 weeks after that, the justices, 3 of whom he appointed, set the case for oral argument for late April. The result will be that a question whose answer was obvious back in December is unlikely to get that answer from the Supreme Court until its session ends in June. I was surprised and distressed that the court set it for argument rather than quickly rejecting it, Dorf told me. You take a couple days, he continued. You issue a 5-page opinion, the upshot of which is, no, a former president is not above the law. There is good reason to remain worried about the conservative justices' handling of the case so far, about how they have already influenced the 2024 election to Trump's political benefit, and about how they could inflict still more damage on the most important democratic process in our country, the presidential election. On the merits, the arguments that Trump and his lawyers have been making are ridiculous, and they have not materially changed since his lawyers began making them over 6 months ago. It's never been suggested that the president can just violate laws with impunity so long as he's acting within the outer perimeter of his official duty, Dorf said. In fact, you might think that the text of the impeachment clause in the Constitution simply resolves the question. Indeed, that clause specifies that a federal official who has been impeached shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. Read with a modicum of common sense, the clause indicates that if someone has been impeached, including the president, that person can also be criminally prosecuted. The clause presupposes the legitimacy of a criminal prosecution against a president, at least after he leaves office. In a tour de force of illogic, Trump's lawyers have claimed almost the exact opposite. They argue that the text of the provision means that the president can only be criminally indicted after leaving office if he was first impeached and convicted by trial in the Senate. That argument makes no sense as a legal, political, or practical matter. Under that reading of the Constitution, a president who was angry about having to leave office after losing an election could nuke an American city at 11:59 a.m. on January 20th, right before his successor takes over, and be immune from criminal prosecution. Trump's lawyers have also argued that the court should infer some form of presidential criminal immunity from the president's immunity from civil lawsuits, which protects them from cases that concern acts within the outer perimeter of the president's duties. The majority reached that conclusion based on structural inferences from the Constitution and the practical consequences of a ruling to the contrary, most notably, the chilling effects on presidential activity that would result if he could be sued by anyone for doing his job. But the analogy between civil and criminal immunity is dubious for many reasons, not the least of which is that anyone can file a civil lawsuit but only the Justice Department can bring a federal criminal prosecution. That process comes with built-in political and legal protections that do not exist in the civil context. The Attorney General is a political appointee who is accountable to the President, who is in turn accountable to the American people. Prosecutors must also get approval from a grand jury to bring charges. At trial, they have to prove every element of their case beyond a reasonable doubt, and the jury has to vote unanimously in favor of a verdict of conviction, none of which applies to civil cases. There are strong policy reasons to reject the comparison as well. We worry about civil liability, Dorff explained, for fear of overdeterrence of inhibiting the president from taking actions in the national interest, but if you eliminate all criminal penalties, and you get a criminal president, then you've got a severe underdeterrence problem. This doesn't mean that there might not be some limited form of criminal immunity for a former president. It's not crazy to think that something like some kind of qualified immunity for a judgment within the scope of the president's discretion could affect how you construe a statute as applied to official conduct, as Dorff told me, but there's nothing resembling that here. The closest they've come up with is to say that as president, Trump was concerned about there being election fraud, and therefore he was ordering the Justice Department and these other people to investigate it. That would be a perfectly fine factual defense at trial if Trump could actually prove it, but there is no reason that highly dubious assertion should shut the whole proceeding down under a fact-free theory of immunity. As Dorff put it to me, the idea that simply because you were doing something that in a totally different universe could have been done by a president for a legitimate reason means that you're immune to prosecution when it's very plausibly alleged that you were doing it for a totally illegitimate reason is quite shocking.